All right, Mr. Lockhart has a note here on one of these tickets. Did you send a note to the court, Mr. Lockhart?
Yes, sir.
Right out of the gate, the tone is set. The judge is trying to confirm basic details, while the defendant signals he's coming in with a script. The mention of a note to the court already hints at unconventional tactics. Instead of clarity, we get confusion, hesitation, and resistance. It's a classic opening where the court expects cooperation, but instead gets a preview of disruption.
Not agreed to these proceedings. All right, so what do you want to do?
I'm here under threat, duress, and coercion. I'd like to say for the record, my name is Jamil of the family Lockhart.
Let's get the record established. This is the city of Detroit versus Jamel Amir Lockhart. Appearance for the record, please, Counselor.
Rita White, House Counsel, on behalf of Mr. Jamil Lockhart.
All right, Mr. Lockhart.
No one is representing me on my behalf.
Now the dynamic becomes clear. The court provides counsel, which is standard and meant to help, but the defendant immediately distances himself from it. This is where things begin to derail. Rejecting assistance while lacking legal grounding rarely ends well. The confidence is high, but it's misplaced, and the judge is already bracing for a difficult exchange.
Lockhart.
Yeah, so I am Jamil of the family Lockhart, flesh and blood, living man, and attorney in fact for Jamil Lockhart and Legis Trust. I'm here by threat, duress, and coercion. I'm here making a special appearance, and I'm here to demand that the court prove jurisdiction over me as a live flesh and blood.
Here comes the familiar script. No contract, no jurisdiction, and flesh and blood human being. These phrases sound powerful, but carry no legal weight in this context. The defendant leans heavily on buzzwords instead of substance, while the court remains grounded in actual law. It's a mismatch between belief and reality, and the gap is widening quickly.
Jurisdiction must be proven and proven on the record. And then also I submitted freedom of information at the request for your foreign registration statement and anti-bribery statement, as well as that of prosecutor. There is no contract. Every presentment that was made to me was formally rejected and sent back to the court, which is what you have a copy of, by my notary. I do have a live witness notary who can come in and testify to that fact. Given that there is no commercial contract, no commercial agreement, I fail to see how the court has jurisdiction. Furthermore, there's been no injured party, and no, there's been failure to state a claim through a verified affidavit. So if someone can prove to me how this statutory commercial court has some kind of jurisdiction over me as a live flesh and blood human being.
The legal foundation is calmly explained, referencing court authority and jurisdiction. This is where reality firmly steps in. The judge doesn't argue emotionally. He explains structure, rules, and authority. It's a stark contrast. One side relies on established systems, the other on personal interpretation. The outcome of that clash is already predictable.
Notice is not what you think notice should be. Notice is what is if it's properly effectuated in the courtroom. And I'll certainly give you whatever hearing that you want if you file the proper motions and material to contest that. I'll give you an opportunity to be heard on that. But furthermore, what I'm looking at is I have a proof of service.
There is no proof of service that was rejected and sent back to the court. You have a copy of that.
You're not even listening. You're not even going to listen. I listen to what you said. Are you going to listen to me?
I am listening.
Communication starts breaking down completely. The defendant interrupts, overlaps, and refuses to listen, while still claiming he's being unheard. This is where the situation shifts from misunderstanding to self-sabotage. In court, timing and respect matter, and ignoring that only weakens your position further.
Statements.
Oh, you had paused. I thought you were finished.
What it isn't.
Well, go ahead.
Are you giving me permission to go ahead now, too, right? All right.
I assumed you were done speaking.
All right. Listen, I have a envelope with certified mail. I don't know what I believe the contents have been stapled to the envelope. It's got a proof of service effectuated by Nyla Perrin. I have a signed complaint here, signed by Officer Randy Randolph on 11/19/2019.
Is he here today?
And we can get him in here. Today is only date and time is set for arraignment. So you're just being arraigned, and what the arraignment purposes of the arraignment, and let's go through the whole thing, is you're here for a expired plate ticket. That is a civil infraction that carries a $145 fine. There's an allegation that you did not have a drove while license not valid or improper. That is a misdemeanor offense, punishable by 93 days at the maximum by 93 days in jail and or $500 in fine. On the same day and time, it was an allegation that you did not provide proper insurance. That is a misdemeanor, as it's written here, and that is punishable by the maximum possible penalty of 93 days in jail and or $500 in fines. There's also a warrant for your arrest for an allegation of an improper, not valid driver's license. So today is the date and time set for arraignment. You have the option of pleading guilty, not guilty, or standing mute. If you stand mute, I'll enter a not guilty plea on your behalf. What would you like to do, sir?
I am here under threat, duress, and coercion to demand
You're
that
not
this
here under threat, duress, or
prove some kind of jurisdiction, and until jurisdiction has been proven.
Judge tries to reset and walk through the actual charges. This is the moment where things could stabilize, but instead, the defendant doubles down on his stance. While the court focuses on concrete allegations, he remains locked into abstract arguments. Two completely different conversations are happening at once.
I'd like to ask you, is this proceeding taking place under common law?
This proceeding is taking place in accordance to the court rules and the statutory laws of the state of Michigan.
So I am not a creature of statute. I am not under statutory law. I would demand that this proceeding take place under common law, as I am a live flesh and blood human being, under no authority but that of God.
All right. I'm not going to go back and forth. I'm going to give you another court date. I don't have any All
I need you to do is prove jurisdiction.
You don't tell me what you need me to do.
The charges are laid out clearly. Traffic violations with real consequences. This is the practical side of the case, but it's being overshadowed by theoretical objections. The disconnect becomes obvious. The court is addressing reality, while the defendant is challenging the framework itself.
I understand that. We can get this over with quicker rather than later if you let me do my job. What I was trying to say, you're making your claim and stating your case that the court doesn't have jurisdiction over me. In order for me to properly review that and go, it's got to be done according to the court rules. I need a motion, and I will read it. I will read that motion.
I have submitted a motion to dismiss for lack of subject matter jurisdiction.
I don't have it. I don't have it in front of me. And then I'll give you a motion.
I have a timestamped copy of it if you'd like me to show you.
All right, you got to submit it to the court. Look at the.
It was filed by the clerk just 2 days ago.
Okay,
I have a timestamped copy of it.
It hasn't got to the file. I'm going to give you another pretrial date.
I would like to say I do not consent. The court has to prove jurisdiction. I filed that document a few days ago. Anything short of that is an admission that there is no jurisdiction, and we have.
When asked for a plea, the response circles back to jurisdiction again. This repetition shows a misunderstanding of process. Court doesn't pause because someone demands proof mid-proceeding. There's a structure to follow, and refusing to engage with it only delays the inevitable.
You're still. Did you have a question, sir?
None other than just stating that I do not consent to these proceedings and I do
You've
not
already
accept
put
any
that on,
contract.
you've already put that on the record.
Good.
You came back in.
I would also like to ask why this Mrs. Rita White had claimed to represent me.
All right, let's go back on the record with Mr. Jamil Lockhart. How old are you, sir?
I am 20.
The judge explains how to properly challenge jurisdiction through motions and procedure. This is actually helpful guidance, but it's not being absorbed. Instead of adapting, the defendant insists he's already done enough without understanding how the system processes those filings.
7 years old, and you go ahead and you ask why Miss White is here to represent you. Well, first and foremost,
Why did she claim to represent me and I have no knowledge?
I'll explain to you. First and foremost, she's the House counsel for this evening. So for this afternoon, she represents anybody who wants her representation as far as helping them to navigate and to defend themselves.
I have never expressed that want to her.
This is what you're doing. This is what I want you to do. Any questions?
Why do you talk over people?
Well, I assume we were having a conversation. I'm sorry. I'll be quiet.
I am trying to have a conversation, but one's got to talk and one's got to listen.
Okay, go ahead.
You asked why Miss White said she represented you. Miss White said she represented you because she didn't know beforehand the position that you were going to take. So she's just merely
quite an assumption.
Her job.
That is quite an assumption. Wouldn't you agree?
Well, by the name that you put up on there, Jamil of the family Lockhart,
That is
I wasn't surprised I wasn't surprised the avenue that you were going to take on that. Just
I'm
by
glad
the
you
name.
recognize
But
where
I
I'm
can't-
going.
But she's not going to assume, I don't believe she's going to assume that she's going to treat you any differently than anyone else. And then you said that you didn't want her representation, and she...
Wouldn't you agree that for future reference, it might be better to ascertain that kind of information before she makes that kind of statement to everybody?
Claim of a filed motion surfaces, but the judge doesn't have it. This highlights a key lesson. Filing something isn't the same as it being reviewed or scheduled. Legal processes take time and proper routing. Assuming instant impact is a major misstep.
Wants her to speak on their behalf.
Yes, until...
Is that not a rash assumption?
Until they say differently, like you did.
Okay. Well, again, this whole time, there's a motion before the court to dismiss for lack of subject matter jurisdiction.
Well, there's not a motion
There has
before the
been-
court.
What has been filed, I have a timestamp copy of it. I can show you that if you need to see it. But
Okay,
your
well,
clerk
let me explain
timestamp filed that document.
Let me explain to you. And this is just for your information. You say that you filed it with the court and the clerk down at the window, and I wouldn't disagree with that. But typically you want to, when you do your filings, that's why you want to have a judge's copy, and you want to specifically have that copy hand delivered to the judge's chambers. So we don't rely on the court clerks downstairs at the windows to make sure that these files get put into the proper place. You're not going to make.
Who do
that
you rely on for that?
You're making, and then because you don't want to make that assumption that that file is going to get into the correct file. You don't want to make that assumption. Would you agree?
Who do you rely on to make sure that filed documents get into the right place, get into
The person that's filing it, yourself.
So it is not, you're telling me it's not the duty of the clerk to ensure that documents are filed.
Even after the hearing ends, the defendant stays to argue further. This is where persistence turns counterproductive. The judge gives him space, but the tone shifts, patience is thinning, and the gap in understanding is becoming more obvious.
We have a live witness to attest to that fact. It has also been time-stamped. That was recorded as well. I have checked all my boxes when it comes to notifying the court. I've also given you a demand for your freedom of information at the request for
I don't
your
have
foreign
any of that.
registration statement and your anti-bribery statement. The idea or the fact that you do not have that is an issue, and it would mean that you are committing a crime against me and holding this statutory proceeding and trying to confuse me as a live flesh and blood man, that I am a corporation beholden to the corporation which you represent. And that is my main point here today, is to tell you that I am not under your jurisdiction. I am a live flesh and blood man. You've already stated that this is not a common law proceeding. I am under no law but common law. We have no commercial contract which would enter us into any kind of statutory law.
Okay.
So
Sir,
I failed to
let me
see
stop.
the
Let me
issue.
stop you.
And there's
Let me-
also
let me
no
stop you,
verified complaint with a
Let me stop you,
signed
sir.
affidavit.
Sir, let me stop you. And I'll let you put that on the record. I'll let you put it on the record already. We've already done those things. So, I'm gonna end
But
it.
you're
I'm gonna-
committing
The discussion about counsel reveals another misunderstanding. The system assumes representation to protect defendants, not control them. Rejecting that help without understanding its purpose puts the defendant at a clear disadvantage.
whatever your position
and
is.
without your foreign registration statement, that's an admission that you are here as a criminal actor.
Okay, sir, I'm gonna end the hearing now.
And I do not consent to
And I'm
any
gonna
further
remove
hearings on this issue or this matter. We have no valid contract. We failed to prove jurisdiction. There is no valid claim.
All right, you've
I do
already
not
said
consent.
that, sir. I've already let you make a record, and I don't want you to mention any more because I'm gonna hold you in contempt of court. Okay, so I'll let you make your record. I set a date.
Do whatever you feel like you need to do. I'm here to
set a
tell
date
you
of
that
March
I am not under
25th,
your
sir.
jurisdiction.
All right.
The judge explains the reasoning behind default legal representation, emphasizing fairness and accessibility. It's a grounded explanation, but again, it clashes with the defendant's assumptions. Instead of clarity, it fuels more resistance.